Hey, it's your old buddy Brian Parker doing another video. This one's in the yoga room, no TV behind me. I'll be getting on the yoga right after this video. Anyway, this is another one of my fun videos. Whenever I see a trust come into a lawsuit, the more prominent the trust is as part of the pleadings or the documents, the happier I get, because it's a chance for me to show you that this trust stuff with its basis of securitization really does exist. Just look at all my 200 videos on my membership website, which is collectionstoppersolutions.com. Excuse me. I want you to like, love, and subscribe to this video. And I also have a task for you today. I want you to tell me how many states does it take to prove or disprove a debt by a lawsuit. And the winners will receive a strong pat in the back, and you get to do yoga with me. But I'm going to have a jar of buzzers right here, and every time I say a state, a buzzer will go off. And we'll see. You got to predict right now how many states are in this lawsuit I'm going to show you. As you remember, a week or two ago, I did a video on breaking down and examining a collection lawsuit with a series 1 through 5. Starts with the summons and ends with the counter affidavit. And you can review them as best or whatever shape you like. Just have the result being after all 5 things are viewed. There you go. I'm already giving you homework. Here's the 5-part series. It's very useful. And it comes with tons of documents all on my membership website. So remember this catchy expression: debt happens, harassment never should. And that's true. We're allowed to have debt, but it doesn't mean we have to get harassed. So I'm going to show you how my client was harassed, because all the cases I try to put in front of you are cases I've already worked on. This one will go away fast. Every time, again, I mention a state, a buzzer will go off. Again, your job, predict how many buzzers are going to go off. So my client had a Cross River Bank loan, who's the original creditor, from New Jersey. Here's the copy of the Truth in Lending Disclosure Statement, Shazam. Got my pointer today. And you can see right there that the lender or original creditor is Cross River Bank. Let me put up the loan agreement for you, Shazam. These loan agreements are all pretty much alike, regardless of what fintech company is doing it. If it's FinWise, Upstart, Blue Ridge, Cross River Bank, they all have the same documents and one-sidedness. What do they call that? Cohesion contracts in law school. But we can get around that by the debt buyer's mistakes. So you see that Cross River Bank is the creditor here. So clearly Cross River Bank is the creditor to everybody. It's undisputed. Unless you are Midland Credit Management, that has filed a lawsuit saying my client is indebted to it as a result of a loan my client contracted with for, no, not Cross River Bank, Loan Asset Holdings Trust 2021-M-2. At least that's what they say. Let's look at the lawsuit, Shazam. And that's just the first page right there, but you can see paragraph 3. Defendant established an account, not a debt, with Loan Asset Holdings Trust 2021-M-2 under a redacted account number, blah, blah, blah. Well, that's not true. You just saw who the lender is from New Jersey. They also, as I said, let's emphasize 3, Shazam, defendant established this account with this weird sounding trust. So maybe that's a mistake. No, it isn't, because MCM doubles down with an affidavit from Minnesota saying Loan Asset Holdings Trust 2021-M-2 create an account with the defendant. And we're putting that up there, the affidavit from Minnesota, Shazam. You can also see that they are claiming my client's a plaintiff, a defendant, and they are plaintiffs long before the lawsuit is filed. We've explained what that is, but it's technically, not just technically, it's wrong, and they've signed this under oath. They've also said under oath, defendants, Loan Asset Holdings Trust 2021-M-2, now they add another word, Best Egg account, was created with defendant, there's no way, but they're saying they were assigned everything from Loan Asset Holdings Trust 2021-M-2-Best Egg, hereinafter referred to as the account. It's impossible. My client doesn't have that, doesn't even know who that is. They then produced an affidavit of an account sale. This is what MCM does. There's a great insecurity, as I've counseled you in the past. They can't just say, we were assigned a debt, here's the paperwork. They have to keep adding to it, things called certificates of conformity. Here's a affidavit of account sale from the great state of Pennsylvania, claiming that a new company who's in the loan paperwork, but that's not enough. Marlette Servicing is selling a pool of accounts. Well, nobody gave anything to Marlette Servicing, so how are they selling anything? And my client, again, and this, I want you to key on this, if your name and account number or anything else about you is not in these papers, these documents of sales, just because they add an extra piece of paper doesn't mean it's in there. It's an extra piece of paper, it's worthless, unless that extra piece of paper is sworn to or certified and refers back to the document they claim is selling your debt, but without your name or account number. So there's no account assignment from Cross River or even Loan Asset Holdings Trust 21-M-2 assigning this to Marlette. But then again, everybody doubles down with these MCM cases. An attorney from Pennsylvania shows up to sign a certificate of conformity. See, again, there's that insecurity. They know they don't have ownership, so they just keep stacking things that say, yep, we own it. That thing we said back there, we're conforming that, which is certifying that, which is from Minnesota, which is from Pennsylvania, in New Jersey. This stuff goes on, and that's just an insecurity. And the more stuff they send your way with their attempt to show they own the debt, shows you that they don't, and it's more stuff than you can explore and expand upon to show the court why you don't owe this debt to these guys. Anyway, I love doing that. To these guys. So the attorney from Pennsylvania shows up to sign a certificate of conformity. Guess what? He says, under New York law, and again, he's from Pennsylvania, real property law. This is a case in Michigan that's it's a collection case, obviously. They're saying New York real property law applies according to the guy from Pennsylvania who says, well, yeah, let me show it to you. Shazam. And that certificate of conformity, let me put something right next to, he's claiming that April Hinsey from Pennsylvania signed this document that proves Marlette, who has no ownership, has the right to send the stuff to Midland Credit. Let's put that next to it, Shazam, the affidavit of sale. So the certificate of conformity is ratifying through New York property law. So look at the second line, that everything that I say happened through Carly Pennell and April Hinsey in Pennsylvania on a case from New Jersey, a debt from New Jersey, ratified by Minnesota in Michigan. And I say that the actual loss agreement states that this case must be brought in New Jersey. Let me put that up for you onto paragraph 24. I just talked in terms of they use the same documents. Now this next part is cool and important for you. They use the same loan agreement, right? And they have a provision called a choice of law provision. They name it different things. Here it's just miscellaneous, but inside, and I've highlighted it, the provisions of the agreement will be governed by federal laws and to the extent that state law applies, by the state of New Jersey. You can only bring it through state of New Jersey or federal law. So they have, all these documents have this special registry provision. They'll say, this thing can be assigned, but only we can assign it and we don't have to give any notice. But they say, if you want to know about any assignments or who owns the actual debt, go to our registry. Sometimes it's called a registry. Velocity does that, or Upstart. Here it's called the recordation in the register. And the register shall be available for inspection by you and any holder, including assigns, at any reasonable time. So you can write them a letter saying, hey, about that provision in my contract, you said I could ask who owns the debt, and I can find out all the assignments, because that's where the registry is keeping everything that's true for us, which you'll never see. I have a letter attached to this video on my membership website that says, okay, I saw your contract. Can you please send me everything you said under contract that you will show me? And I have a follow-up letter because they're going to try to blow you off. So that's attached to the membership website, contacting the registry. So if you're keeping it score at home and you want to win this buzzer provision, this is a Michigan case on a New Jersey creditor agreement supported by an affidavit from Minnesota, with another affidavit itself from Pennsylvania, backed up by an attorney from Pennsylvania who says New York real property law applies, and that by contract can only be filed in New Jersey. So I was talking at the beginning in terms of those 5-part series. The 5th part is how to create and build your counter affidavit based on all the other stuff that you learn and gather from the first 4 parts. Meaning, analyze that lawsuit of yours, whatever state you're in, just apply your facts and law through the prism of that 5-part series. They're only like 8-minute videos, and they'll set you up very nicely. It's on my membership website. But that last thing I mentioned, the choice of law, that tells you where the case should be, and it's rarely in the case where you are. These are all bricks that make a nice wall for you. This case will get thrown out. I filed the answer today. I bet you this is done at the end of the week, and it's quite a hefty debt, but we've got them dead to rights. So attached to my membership website will be my show notes, which tells you how I look at these things, how I analyze. 2 counter affidavits, I'll give you 2 for the price of 1. 2 answer and affirmative defenses that incorporate both answer and affirmative defenses and answers incorporate weird sounding trusts that MCM claims sold them the debt, which is not possible as the original creditor when that's not possible. I'll give you that, again, those registry letters and follow-up letters. And I ask you to remember, debt happens, harassment never should. And if you agree with that, like, love, and subscribe, and we'll keep bringing the good stuff. Again, go to my membership website. It's chock full of great things, 290 videos. There's probably 1,000 word templates there for you to choose and just incorporate with your state and facts. Again, Brian Parker here, bringing you the good stuff. Thanks a lot. Hope this helped, and I hope you have fun with any trust-related cases. Bye-bye now.